Thanks for staying with us. Again, my name's Les McFadder with Perry & Young. This is Law Call. We're taking your questions live. Tonight we are talking about family law with our guest Gerard Verga, of the Verga Law Firm. We just had our first segment where we answered a couple of emails, took a phone call about enforcement of divorce orders. Let's talk a little bit about child custody.
Okay.
I know that obviously anytime when people are going through a divorce, it can have a very detrimental effect on the kids. And usually you have two parents that are really kind of jockeying for more timeshare. How does a judge, how does a court determine what is an equitable or fair timeshare between a mom and a dad, both of whom want to have involvement and have their kids as much as possible? How do they, do they just split it down the middle, or how does that typically work?
So when I first started out, if you were a dad, honestly, you were very lucky to get every other weekend. And then it kind of got more progressive with the judges doing it, where you'd see a lot more 60-40, 70-30, timeshare splits. Then in 2023, the legislature actually enacted a presumption now, and the presumption is for equal time sharing. And we're seeing courts really treat that as a very strong presumption. The courts are still going to have to go through all the best interest factors, which are in 6113. But the presumption, the majority of the time, is going to win out unless you have some very substantial evidence of bad parenting.
Okay, so right now, and that, I was always taught that. I went to law school in the 90s, dating myself. But I remember when I first started, and I was taking my family law classes and getting a little bit of experience in different areas, I remember always thinking that, like you said, the fathers typically got very, very low percentages for whatever reason it may be. But now you're saying that the presumption is 50-50 unless it can be demonstrated that not to do that would be harmful to the kid or not in the best interest of the child?
Best interest is still our standard, so yes, it's going to be, the presumption of 50-50 will carry unless you can bring some evidence that would show why 50-50 wouldn't be in the best interest of the child. And even though the law still is best interest, I would kind of proffer that we really, at this point, trying to show a detriment.
Okay. Now, the second question I would have is, at what age does a child have the ability to go in and give either their preference, or does the court, I guess, give some deference to the child? Because I would imagine, once they turn 18, they're adults.
Right.
At the age of 5 or 6, they may not be able to speak for themselves, understand what's going on, but you get kids that are 12, 13, 14, they understand what's happening. How does that factor into child custody, timeshare, things like that?
So in the statute for child custody 6113, the court can look at the child's preference. That's one of the statutory factors. And the court does want to look at their age and maturity and things of that nature. It's not controlling. It's just one of a large number of factors the court's supposed to look at under the best interest standard. You normally have to do a motion, ask for the court to allow the child to testify. Can't just put the child on the witness list. The court has to make a determination before the hearing that they want to hear from the child. And then what we're seeing a whole lot of is a judge says, I will talk to the child in chambers, which is called in camera, and I'll have a court reporter there. If you want to submit some questions to me beforehand, both sides, I will consider those. I may ask them, I may not. And it goes from there. And if you want to know what the kid said, then you order the transcript. But it's kind of evolved. I had early on saw cases where the child's on the witness stand, and it's a horrible place for a kid to be looking at mom and dad in the middle of a courtroom. So I think this procedure is much better if the court wants to consider that.
Is that something that judges typically will default to anytime there's a child, to say, hey, let's do an in-camera, it has to be recorded. They have a court reporter there, but you're not putting the child in the witness stand. The kid's not sitting there answering questions, looking at mom and dad, looking at them. I can see how that will be very stressful on a child. Is the default, is it more common to have those in-camera type
I would think now, in the last 5-7 years, I don't think I've seen it done any other way. Dating myself, back in 2005, 2006, I would see cases where the child would be in the judge's chamber because the whole hearing was being done in there, and the child's getting subjected to cross-examination and it just wasn't a pretty sight. So I really like the in-camera procedure. I think it's a good compromise for the kid to have a voice in it if the court thinks that they're old enough to do so and mature enough, and not put them in the middle of that. And you can still, hopefully get the evidence in that you need to get in.
Very good, very good.